I think it's C-3489.
I have a PR with a drug patch.
That's the agreement. Thank you.
Okay, good afternoon, everybody. Today is Monday, August the 5th. My name is Judge Esparza. We have some writ hearings scheduled this afternoon. I did swear in all the defendants earlier. The first case we're going to call is, see Mr. Pasan here, C-3489-24-I, State of Texas versus Jose Cepeda. English, Mr. Cepeda?
Yes, sir.
Okay, step up to the front, please.
Good afternoon, Your Honor. David Lynn for Mr. Cepeda.
Move back a little bit. Good, face the TV monitor. Good afternoon, Mr. Lindemuth. This is your motion. He is present. You may proceed.
Your Honor, I did speak to the state. My understanding is we've come to an agreement subject to the court's approval of PR bonds for my client for the 3 allegations against him, but he does need to have a drug patch.
That's correct, Your Honor.
I only see 2 charges, 2 possessions. You said 3?
Yes, Judge. He was also arrested for display of fictitious motor vehicle registration. If that's fallen off, maybe it fell off by now.
Yeah, I think the complaint has already been filed on that one. Landed in court for. He's also got a, I think a motion to adjudicate out of court for. Not set till August 21st. So even with the PR bonds, he's not going anywhere.
I understand, Judge. I'll get to work on those.
Okay. Mr. Cepeda, you're going to be released on these cases with a PR bond and the condition that you get a drug patch, which is something that probation will contact you. You're going to have to put it on there and wear it. And every 2 weeks you go in and they'll switch it out for another one. If you come back positive, you're going to come back to jail. Do you understand? No drugs, no alcohol. Is that clear? Bond on the possession of controlled substance penalty group 1-/1 be reduced to $3,000 PR. And the other possession charge will be a $2,000 PR with the drug patch. Anything else, David?
Your Judge, that's all I have. May I be excused?
Yes, sir. Thank you.
Thank you, Judge. You have a great day.
Question, Your Honor. So I'm gonna be here until the 21st.
Well, your attorney's gonna talk to the court. Maybe they can move that date up. But right now it's set for the 21st. He'll notify you if he gets the date moved up.
I'm basically like scheduled a release, right? Like it's
He'll notify you. He's gonna, like I said, he's gonna contact the court and he'll notify you if he can move it up or not. Good luck to you.
Thank you.
Yep. Robert Puente here. Yeah. We're gonna call C-3506-24-L, State of Texas versus Gerardo Coronado Jr. Speak English, Mr. Coronado?
Yes, sir.
All right. Robert, this is your motion. He's got 4 counts before the court. You may proceed.
Yes, Your Honor. He's got 4 counts, 20,000 and 25,000 respectively for each of the counts. So there's 2 of them for 20,000 and 2 of them for 25,000. Combined, this is beyond his financial means to make a bond. We ask the court for any consideration of lowering the bond to an amount that he could afford. Fortunately, I was assigned this case rather just soon, so I haven't had a chance really to explore what kind of financial means he has, Your Honor. And I apologize for that. But we were just asking for any consideration towards the amount.
All right. What says the state?
Your Honor, the state wouldn't have any objection to reducing the bonds, but we'd ask that they be reduced to no less than half of their current amount.
Mr. Coronel, how old are you, sir?
I'm 30 years old, sir.
You have a job?
Yeah, I work in home health.
What do you do?
Well, I'm a caregiver. I take care of the elderly, you know?
You're a provider?
It's,
How long have you been doing that?
I studied for medical assistant also, so
How long have you been a provider?
I've been a provider for over 10 years.
What city do you live in?
I live in Par right now, sir.
A house or apartment?
Apartment.
You married?
No, sir.
Children?
No, sir.
I'm gonna order monthly UA, sir. If you make bond, I'm gonna order that you get out and probation will contact you to get drug tested. No drugs, no alcohol. You come back positive for either one, you're gonna come back and sit in jail. You understand me?
All right, sir.
Bond will be reduced on each count to $2,500 cash surety times 4, be a total of $10,000.
Okay. So what would that mean?
Talk to your attorney, talk to a bondsman. They usually charge anywhere from 10 to 15%. You have to work that out with them, though. I don't have any control over it.
All right, thank you.
Anything else, Robert, on that case?
No, Your Honor.
All right.
Thank you.
Good luck to you, sir. Next case we're gonna call is C 3497-24-L, State of Texas versus Jesse Espinosa. You speak English, Mr. Espinosa, correct? Okay, go ahead, stand up there in front. Nereida, this is your motion. Client's present. You may proceed.
Yes, Judge. My client is in the Hidalgo County Jail charged with a sexual assault, Judge, a second-degree felony. He is a U.S. citizen. He lives in Weslaco. He lives there with his current partner. 2 boys that are, one is 10 and the other one's 11. He does have 2 older children from a prior relationship, and that is a 17-year-old boy and a 16-year-old girl. He believes that this allegation of sexual assault could be against his daughter, his 16-year-old daughter. He has not seen her for over 2 years, Judge. Doesn't really have contact with her. And at this time, he is requesting a bond reduction to $25,000. He understands that this kind of case generally carries a some type of a protective order to stay away, in this case, from his his older daughter. Again, he hasn't seen her for over 2 years, Judge. And I spoke to him about the possibility of AIP. He is willing to abide by those conditions. He is self-employed, Judge, and what I call a catering job. He simply told me he did, I think, barbecues for other people and got paid for that. So his kids are getting ready to go back to school, Judge. He'd like to go back and be able to continue providing for him and then await the rest of the process of this case, hopefully outside of county jail.
Okay, what says the state?
Judge, based on the allegations and the nature of the offense, we feel the bond is reasonable as it stands.
Espinosa, how old are you, sir?
38, sir. And there's just one correction.
Hold on. Let me ask the questions, all right? What city do you live in?
I live in Edward, right by the courthouse.
How long have you lived there?
Going on 3 years now, sir.
You rent or own?
It's a home that we are buying to own, renting to own, sorry.
There was a protective order that was issued, sir, by the magistrate. And the protective order requires that you not have any contact with the alleged victim. You will be given a copy of this if you make bond. You are not to possess a firearm. You are not to communicate in any manner. No text messages, no instant message, anything, Facebook messages. with the victim or the victim's family. Do you understand that? This will be for 61 days, but I'm going to ask that it be in effect until this case is resolved. You're not to go within 200 yards of the home on Mojave Street in Edinburgh.
Right.
Okay, don't go within 200 yards. Don't be driving by there. Don't be passing by there. You understand?
Yes, sir.
All right. Where do you work, sir?
I work for myself. I work out of my home, actually. I like my lawyer said, I cook for Bogus Ford, Fiesta Chevrolet. They have an event, I make brisket, turkey legs, stuff like that.
All right. I'm gonna order bond be reduced to $25,000. Cash surety. No contact with the victim or the victim's family. You understand?
Yes, sir.
Anything else, OJ, you want to add to that?
No, Your Honor.
That is all I have, Your
Anything
Honor. Nothing else. May I be excused.
Yes, ma'am. Thank you. Have a good afternoon.
Thank you, Judge.
Have a seat, sir. Good luck to you. Next case we're gonna call is C 3493-24-E, State of Texas versus Jesus Avila. You speak English, correct, Mr. Avila? Mr. Basan, this is your motion. Not sure if you're aware, but he does have, it's like a motion to adjudicate and maybe another pending felony, or maybe it's two motions to adjudicate. I'm not sure. I know he's got one for sure.
That is correct, Judge. He does have a motion to adjudicate, and he may have another matter that he's being held without bonds. In addition to those, Judge, he's before the court on an alleged robbery in which his mother is the alleged victim on that case. His mother was actually just here in my office right now, Your Honor. I've been speaking to her, Mr. Avila, their family as well. Respectfully, Judge, his bond right now for the robbery is at $45,000 cash surety. In speaking to the family, this coupled with the other cases, it's something that they cannot afford. As evidenced by my appointment, he is indigent. Your Honor, respectfully, we're asking for the court to consider lowering the current bond of $45,000 to somewhere in the $10,000 cash surety range. Judge, in speaking to his family, they disagree with the charge, Judge. They don't believe that it amounts to a robbery. It appears that there was a dispute. However, at the same time, they're not saying it didn't rise to the level of this, Judge. So in light of that, we are asking for the court to consider reducing the current bonds, Judge.
It says the state.
Judge, we object to the bond being reduced. This defendant was already out on bond on 5 different felony cases. He failed to appear for court back in December of 2023. There were 5 NICIDs and cases outstanding for him. He's shown that he will not report to court based on the bonds. So he is a flight risk. It's a violent offense. We feel at $45,000, the bond is reasonable.
Mr. Avila, how old are you, sir? How old? 50. What city do you live in? Who do you live with? Sir? Who do you live with? My mother. You have a job? Sir. Where do you work? Truck driver. CDL? Sure. When was the last time you were driving? About a month and a half ago. In state or out of state? Out of state. And then, Stan, you have a motion to adjudicate in CR 5162-22A, and I don't believe there's a bond set on that case at this time. They're alleging a burglary of vehicle from January, credit card charge from January, and some other violations in addition to this charge now. Big bond, I'm gonna order monthly UAs. you'll have to report to probation and get drug tested. You show up when they tell you to show up. The rest of you that I ordered the drug testing, not when you want to go. You show up when they tell you to show up. You understand? Bond will be reduced to $20,000 cash surety. Anything else, Mr. Basan?
Nothing further, Your Honor. May I be excused?
Yes, sir. Have a good afternoon.
Thank you. Mr. Avila, I'll be talking to you later.
Thank you. Good luck to you, sir. Next case we're gonna call is C 3523-24-E, State of Texas versus Brian Mann. English, Mr. Mann?
Sure.
Is present. Jaime Aleman, this is your motion. You may proceed.
Judge, good afternoon. Basically, what we're looking at right now, my client's in custody on a $10,000 cash surety bond on allegations of a violation of protective order with 2 or more violations. Judge, I did have a chance, the state did forward a copy of the probable cause. I do appreciate that. In looking at this particular case, Judge, this is a case that stems out of, he was been in custody basically since July, but the incident reportedly came from an incident in October. I know that this particular allegation involves a protective order. My notes, I've been working on this case, to be honest with you, with my client for quite some time. He, just for the court's benefit, is currently pending an allegation of burglary habitation with the same alleged victim from a case from 2022. I will also let the court know that this has been one of those on-again, off-again relationships. When he was previously arrested, the alleged victim on this case had shown up to court in Judge Noe Gonzalez's court at a writ hearing, saying that she didn't want to proceed with charges. It didn't happen at all like it was alleged. That goes back to that burglary habitation. In other words, we're going to have to get that all cleared up someday, maybe even go into trial on that case. So what we're looking at, Judge, I did have a chance to look at the probable cause, and it's essentially a situation where the alleged victim, she was in a pool. Officers responded because there was a call for help because this lady had been in distress. My client was there, sort of seen amongst the people trying to help her. She refused medical attention, and the case was sort of like let go at that. But because the investigator saw that my client was near her, not that she wanted to press charges or that he assaulted her or anything, but just he was there at the scene, they filed through with this complaint, or I guess the probable cause affidavit. So, we don't see her, pressing charges or that he, tried to assault her or anything like that. If anything, he was there trying to help her. So we feel, Judge, this $10,000 cash surety bond is excessive, considering the true nature of the allegations, and given my understanding that Ms. Larson, the alleged victim of this case, has previously addressed the courts many times, saying that she really does not have a problem with my client, Mr. Mann. And my understanding, my notes show, and I didn't represent them on this original, but the protective order made the subject of this quote unquote violations was set to expire in May of this year. So that's already come and gone. So my client is indigent. He does not have any financial means, Judge. I am court appointed counsel for Mr. Mann. He is set for court to appear in the 476 on August 22nd. He's always made every court hearing, Judge. So we're asking for a PR bond pending further court action, Judge.
This is state.
Your Honor, I agree with Mr. Aleman in the sense that there is a complicated history regarding the defendant and the victim on the protective order. Just looking at some of the dispositions that have come up. She seems to come in and drop charges every time. We'd like to have him on a surety bonds, but so I'd ask that it be reduced to maybe 3,000 cash surety with a no harmful contact order.
The magistrate who arraigned him issued another protective order, emergency protective order, Jaime.
I don't know that, Judge. I don't have that information. Are you telling me or asking me?
No, I'm telling you, he did issue
Okay.
another one for
Okay.
61 days. You're not to have any contact with the Carrie Larson. What's your address, sir? Where do you live?
Edinburgh, Texas, 112 RV Park, 107.
Yeah, how far is your lot from a lot?
109 is more or less the range of that. It's that she's lived there for so many years.
This is my question. How far is your lot from her lot? 200 yards?
3 blocks.
Don't go by her house. Listen to, I'm not asking you any questions, so I'm telling you, I'm giving you an order. You need to listen. Don't go driving by her house. Don't go walking your dog or walking down the street by her house. You understand me?
Sure.
You will be arrested. There is a protective order. You will get a copy of it when you leave. It's good for 61 days. It'll expire on September 23rd, a month from now, a little over a month. So between now and then, listen to your attorney. Do not go within that neighborhood or down her street. Is that clear?
Yes, sir.
Bond will be reduced to $1,000 cash surety. No harmful contact with the victim. I believe the protective order also says, no firearms, sir, not, that you not possess any firearms. So if you have some in your home, you need to make sure that before you get there, they are taken out of your home because that is a violation of the protective order. You understand me? Anything else, Jaime?
Nothing further, Judge.
All right. Thank you. Have a good afternoon. Good luck. to
Thank
sir.
you. Thank you, Judge.
Pearson, we're gonna call C 3500-24-L State of Texas versus Eric Nichols. English, Mr. Nichols.
Yes, Your
Uh,
Honor.
Mr. McPherson, your client's present. You may proceed.
Judge, my client was arrested on July the 19th, 2024. I've been dealing with his wife. She was going to bond him out of jail. The sheriff's office had posted this bond at $1,000. She had made a deal with the bondsman on this case and 2 other cases he was in jail on. The bondsman took $1,000 from my client's wife to bond her out, to bond him out. When the bondsman was at the jail making the bonds, the sheriff's office informed the bondsman that they had made a mistake, that the possession of controlled substance bond that showed up as $1,000 was actually $10,000. So the bondsman kept the wife's money. He wouldn't refund it. And that's the way it stands today. He still has the money. He's willing to bond the defendant out, but the bond needs to be reduced either to a PR bond or $1,000 cash or surety as originally shown. He is an American citizen. He lives in McAllen, Texas.
What says the state?
Your Honor, we're asking, we don't have any objection of it being reduced, but we're asking it not be reduced to less than half.
Mr. Nichols, how old are you, sir? How old?
46, Your Honor.
Your job, sir?
No, sir, not at the moment.
When's the last time you worked?
It's been like 2 years after I got stabbed. I'm living with,
Where do you live? What city?
a guy with Young,
Who do you live with?
a friend of mine.
I'm gonna order monthly UAs. Get out on bond, sir. You need to report as ordered by probation to get drug tested. You come back positive for drugs or alcohol, you'll end up back in jail. Is that clear?
Yes, sir.
Bond will be reduced to $1,000 cash surety. Is that what you're requesting, Mr. Pearson?
Yes, it is, and I appreciate that.
All right. Good luck to you, sir. Make sure you stay in contact with your attorney. So just get you out of court. You will have to show up at the courthouse at a later date to take care of this matter. You understand that?
Yes, Your Honor.
Like I said, make sure you stay in contact with your attorney. Good luck to you.
Thank you, William.
Thank you, Judge. May I be excused?
Yes, sir. Have a good afternoon. The next case we're gonna call is C 3482-24-H, State of Texas versus Efrain Tenopala Jr. You speak English, sir? Good. Lily Gutierrez, this is your motion. Client is present, he does speak English. You may proceed.
Yes, good afternoon, Your Honor. Lily Gutierrez on behalf of Mr. Tenopala. Your Honor, Mr. Tenopala does have some cases pending. He has a motion to revoke and a DWI, both out of the 332nd District Court. There was an so apparently the DWI that's already been filed, the CR 3611-24F was appointed to Christopher Cavazos, attorney Christopher Cavazos, and these new the motion to revoke and he has a new DWI at felony intake were appointed to me, as well as a reckless driving misdemeanor that's on file already. And Your Honor, they were set for this morning, and as I made my way from other courts, it turns out that Judge Ramirez was going to determine who was going to take the cases. He determined it was Mr. Cavazos. He got there first. I'm not sure if any of the bond issues were addressed for those two cases. So I'm just making the court aware that there are other things that might hold him, especially that motion to revoke. He's got no bond on that. And so on the DWI that's pending at intake, that's the one we are before you this afternoon, Your Honor, and he does have a $30,000 bond. My client is a United States citizen. He actually has he's the executor of his father's estate. It was quite a large estate. And so he does have responsibilities that he needs to get back out to. We are asking for a reduction in the bond. He's been in custody a month at this point, a little short of a month. And we would obviously accept a PR bond. However, because of the fact that he's got other cases, if the court's not inclined to give him a PR bond, we would be asking for something low, like a $2,500 cash surety bond. Otherwise, he might not be able to make all of his bonds and be able to get out and take care of not only these cases, but the other responsibilities that he has.
There's the state.
Judge, we're opposed to any reduction. Just so I'm clear though, my understanding was we're addressing the bond that he was arrested on May 14th for a DWI. And then he was arrested on a new DWI in July
That's correct.
and that DWI in July has been filed. So we're addressing the May one, which is set at $25,000 cash surety. Is that correct, Ms. Gutierrez? Because you said 30,000.
I believe that it was the May 14th case that's been filed under CR 3611-24F. At least the docket sheet indicates that the offense date is May 14th of 2024. I don't believe the July DWI has been indicted.
It has been indicted.
It has?
It's CR 4017-24F.
Well, then, Your Honor, in that case, I think this issue is moot. And I guess I will check with Judge Ramirez's staff with respect to getting this to Mr. Cavazos.
Okay, yeah, because looking at everything, I wasn't about to reduce the bond. I didn't see with 2 DWIs, felony DWIs, the facts of the case. So, and you said it's been indicted, OJ. What was the cause number?
With the July one, Judge? It's 4017-24F.
Mr. Tenopala, what that means is your case, this new DWI is going to land in the 332nd with the judge. Were you in court this morning? Okay. That case is going to land in there too. I no longer have jurisdiction over it, so that judge will have to decide if he's going to let you out on a bond on this case and all the other cases you have. Understand that?
Well, I was already on bond.
Okay, well, you picked up a new charge, which is why you're in jail right now. That charge has been indicted and it landed in the 332nd with Judge Mario Ramirez. I no longer have control over or jurisdiction. He'll need to, your attorney will need to set a court date with him and address the bond on that arrest that happened in July. If he gives you a bond on those other ones, or he decides to revoke those bonds, that's up to him. Your attorney will have to address that with him. Understand?
So I don't get no bond.
You do have a bond right now. It's $30,000. I can't reduce it, is what I'm telling you.
So I only have one $30,000 bond, right?
And then one of the other charges, there's a motion to revoke. It says no bond. And then the arrest from, there's a misdemeanor charge that has a $3,000 bond. And then the DWI from May, the bondsman surrendered the bond, and that one was what, 25,000? That was set at 25,000. So we'll either have to post that bond again, or maybe you can negotiate something with the bondsman. I don't have any control over it, or maybe the judge will reduce it.
If I pay the $30,000 bond, I'll be able to get out.
No, not right now, because one of the cases says no bond,
Which is the motion to revoke.
the motion to revoke. All right, all right, good luck to you, sir.
Thank you, Your Honor. I will file a non-suit on this case.
Okay, just so you're aware, Mr. Tonapala, there was a order that you get an ignition interlock device. I don't know if you had it. It was ordered in May. So you need to make sure you comply with that, sir. Okay, thank you, Lily.
Thank you, Your Honor. Bye-bye.
Anybody's name I didn't call? Is everybody right? Okay. All right, gentlemen, good luck to you. Thank you, OJ.
Thank you, Judge. Have a good one.